ClickUp replaced like 5 different tools for me. We had tasks in one app, docs in another, meetings somewhere else. It was complete chaos. Then we moved everything to ClickUp. And when we turned on the AI agents, game changer. It's not just AI chat. It actually runs workflows inside your workspace. It feels like we added support without adding headcount. If you're leading a team, open a free ClickUp workspace and try the AI agents.
Malcolm? All right, we are ready to start the day's proceedings. 29 minutes past 9 exactly. Let's make sure that our cell phones are on silent. Let's make sure we don't disturb the proceedings. Thank you.
Good morning, Ms. Sello.
Good morning, Chair. Good morning, Commissioners. Commissioners, today we start before you two applications in respect of two witnesses for their testimony to be heard in partial camera. In anticipation of the respective orders being granted, we've taken the liberty of naming one witness N and witness O, and we're just simply following the order of the witnesses thus far in camera. I will start with the first witness, which is the witness N in camera application. You should have before you two bundles, one for witness N and the other for witness O. Please don't look at the spine island that it is mislabeled as statement, but it's actually the in-camera application. Should be the only two files before you. Now, if we turn our attention to witness N's application, at the get-go, I must disclose to you, Commissioners, that the application was served out of the prescribed time period. And we start by asking for condonation for the late filing of the application. It was filed, as I understand, yesterday morning, eventually, scheduled for Wednesday evening, but for reasons that are not immediately necessary for the moment, it was filed yesterday morning. It was duly received by the press, and there's been no indication of any opposition to the application. So first and foremost, we would like to apply for condonation. The basis for the
please repeat what you are saying about the evening, because you say service was in the morning and then you said something.
I said it had been due for service the Wednesday evening.
Oh,
actually the service was effected only yesterday morning. So there are different reasons for the late service of these respective applications. In respect of witness N, the witness was scheduled to testify in person. If then I may turn to the actual affidavit to explain the circumstances that led to this application being moved. And for that purpose, I would like to refer you to page 5 from paragraph 5. This witness is a female, adult female, and member of the PKTT team currently deployed in the Eastern Cape to investigate matters relating to the University of Fort Hare. So that's her main assignment, and that's where she has been. During the course of investigations, through an intermediary, she was approached and informed of a complaint from members of the public relating to a specific senior investigator at IDEC in the Eastern Cape. She was approached because of the trust reposed in members of the investigating team in the Fort Hare matter. She took the matter up and investigated and concluded that the concerns expressed warranted further investigations. She registered an inquiry and proceeded with the investigations. Her challenge now becomes, because she is part of a bigger team investigating a much broader issue, the Fort Hare issues, the disclosure of her identity, both physical in terms of her pictures and images, and her name, risks the inadvertent disclosure of her team members in the entire Fort Hare investigation. Their success thus far is based in large part on the fact that they are quote-unquote anonymous, and they are able to access the community, and those who want to provide evidence insofar as Fort Hare is concerned are comfortable to approach them and be seen with them. She, as part of the investigating team, is protected by members of the NIU and TRT, and is always in their company. The disclosure of her face and her identity will by definition extend to the members of her protection team. That would require the PKTT to replace almost the entire team that has been seen in her presence and reconstitute the team for the purposes of the Fort Hare investigations. Her employers expressed serious concerns with that and the unintended impact on the original investigation for which she is tasked, and requested whether her identity could be withheld, but her testimony in no way will it be curtailed by these issues. So the application is that she testify virtually, remotely. Her voice will not be distorted, her name will be withheld, and her images will not be distributed. And that is the application insofar as witness N is concerned, Chair.
Paragraph 6, having said everything that you've said, do you think paragraph 6 is necessary? Of the notice of application or notice of...
Of the notice or of the affidavit, Chair?
Of the notice, Even seven.
I agree with you. It's,
It
it's
looks
overly
like
broad. It defeats the very purpose of the application being made. Now, her testimony is not subject to any non-disclosure, and her transcript would be freely available as any other, except under the new name of witness N.
It seems.
Absolutely, Chair.
You simply used a precedent, I assume.
That's the risk of precedence, huh?
Yes.
And judging by what the Chair says, that must be a problem that afflicts the next application, but we'll deal with it at the time when the time comes.
I take it you'll report yourself then.
For, I'm happy to report myself, Commissioner, as long as I know what for. Misconduct.
I will do as I always do in these applications. I'm not going to rattle off what you have in the notice of application. I'll just say the application is granted. And then you will furnish me with a draft order for me to have a look at, and then the Commission Secretary will sign it.
As I understand, the draft order has been presented and should be in your bundle.
Let's finalize all of that at a later stage.
As soon as I have disposed of both applications, we shall make the respective
For your present purposes, application granted.
I'm indebted to the
Thank
Chair.
you.
Thank you. The next application then is in respect of witness O, following the order of things. Today, the commissioners will actually hear evidence from four witnesses. 3 witnesses cover the same issues, but they play different roles. The application the Chair has just granted in respect of witness N is a separate issue. Now we are left with the other 3. Of the 3, 2 will be present in the auditorium to testify. These are investigators into an issue that had arisen some time back, but their investigations were triggered by a whistleblower. So effectively, the facts they relied upon to initiate the investigation are, for your purposes, we concluded hearsay. The original whistleblower is prepared to testify to confirm the correctness of the reports she had made to the investigators and any documentary evidence she may have given in support of her report. That whistleblower, however, is a member of SAPS, is currently in service, and has got serious personal concerns. One is she was eventually persuaded to report the matter, but only as a whistleblower, to enjoy the benefit of anonymity while shedding light on the concerns there may be. Her disclosure was then initiated in terms of the Protected Disclosures Act, and her name has not been circulated or published in any manner. She would like to assist the Commission to provide the necessary evidence, but would prefer that the anonymity extends. Since she reported the matter, she has had no negative reaction from, in particular, her seniors and her colleagues within the SAPS environment. She fears that if her identity is now disclosed, she may suffer pushback and some level of occupational detriment, including intimidation or any other that may eventually affect her employment. Her request is for the Commission to extend the protection afforded her by the Protected Disclosures Act and as a whistleblower, and not require her to disclose either her name or her physical identity. And it is on that basis that she moves the application for an in-camera. If the commissioners are inclined to grant it, the idea is that she, as with witness N, will be testifying virtually, remotely. Her voice will not be distorted. It is accepted that those people who are impacted by her evidence will know who she is. And that has always been the case, even during the stage of investigation. But the broader SAPS community doesn't know who she is, and that is what she is quite desirous to retain. And that is the sole basis for why she is in camera. She will take any questions that the commissioners may have for her, particularly because the investigators significantly relied on her own documentation and report, as long as the questions do not run the risk of disclosing her identity within the SAPS environment. That is the second application and the basis for moving it. And equally, it's partial in camera, and she's scheduled, I think, sometime today in the afternoon.
I didn't hear you apply for condonation. Must I assume that
Yes, Chair.
service was
Service was late, and if the chair has regard to the notice of motion, once again we apply for condonation.
I do see it signed 9 July.
Yes, thank you for bringing it to my attention. Yes, the late delivery of this particular application was a delay in determining whether or not her evidence is wholly necessary before this commission, or whether it is sufficient for the investigators to run with the whistleblower report she had made. Some issues for clarification became apparent, and neither investigator could speak to those issues. She was quite reluctant to place herself on this platform, and it took some persuasion. And I think she was only the day before yesterday, or yesterday, finally persuaded with the necessary level of support to present herself before you. So this is a sort of a late determination to present this witness. But now we find ourselves in a position where her presentation of her testimony has got these attendant difficulties. Thank you, Chair.
Thank you, Mr. Law.
Ms. Elo, if you would perhaps just clarify where you speak about persuasion, that she was persuaded. It's capable of an understanding that you may, or the commission may have gone out fishing for a witness to come and testify. If you could just explain that part.
No. Thank you, Commissioner Balu. To the contrary, the evidence leaders worked with the investigators. They've got their docket relating to that particular investigation. But the underlying cause of investigation was the whistleblower's report. The report is available, as I understand it, but there are certain issues around the events on which she blew the whistle that would require engagement with her, and it became necessary to consult with her. The consultation itself was not an issue to clarify. The question that arose was, in light of some facts not contained in the original report, can the investigators purport to give clarity on that? And it was determined that perhaps Her appearance before yourselves would serve to clarify all factual issues surrounding the incident, and therefore enable the investigators to act in the manner they did. The persuasion was in relation to her giving clarity directly to the commission, because that required that she appear. Does she stand by her report? Absolutely. Does she stand by everything the investigators did? At her instance, she does. She was just interested in retaining the anonymity and not be known that she was the instigator of the entire investigation. As I indicated, both investigators would, in essence, if they speak to some fact that they learned from her through engagement and consultations which they did, but that is not reflected in the original report she made, would basically be testifying on the basis of hearsay. To cure that, it was considered that if she avails herself to deal with all material facts around that issue, then any hearsay that would have been testified to by either investigator would be cured by her own appearance. So persuasion was not because she was hunted down or sought by the evidence leaders. Her identity, her name, and her report was always available. It was a question of how are those facts presented to the commission. Thank you.
Thank you.
So it was more an issue of how anonymity would be maintained.
Indeed.
That's
indeed, Chair.
all.
That's the only
No
issue.
reluctance at all with regard to the content of the testimony. There she was prepared to testify.
Yes.
But how do you make sure that my identity will not be disclosed?
And that's the only basis, as I say, for which she moves the application.
Thank you, thank you.
And I wanted to add, Advocate Silo, that she was willing to give the statement, the issue of anonymity related to her appearance.
Was she willing to give a statement to the commission? She could have given a statement to the commission, but then she would have still had to be a witness or some witness. And the question was, if she's willing to give a statement, questions arise in the course of presenting the statement, and we thought the commission would best be served by her being available to clarify some questions that the benefit we wouldn't have if she just submitted a statement. Because as I say, the original report she made is in the docket, and she would have made a statement more or less along the same lines. So the issue was if she could avail herself to provide any clarity that the commissioners may require, and once again on the basis of anonymity.
The earlier comment with regard to 6 and 7
As I had
applies
said.
here?
Yes, thank you.
I will do what I did with the first application, which is merely to say the application is granted. You will attend to the content afterwards.
Definitely will do,
The full content.
Well, we shall do so shortly, Chair. I'm indebted to the commissioners. Commissioners, we are ready then to start with our first witness. Maybe if we get 2-3 minutes to settle down, to bring the witness in, and we should be ready
We'll
to
stand
start.
outside. Let's adjourn.
Thank you.
It's not necessarily 3 minutes. We'll come back when we are told to.
There comes a point when you stop chasing what's next because you finally arrived somewhere worth being. And along the way, progress starts to look different. The way you spend your time, the choices you make, the standards you set. That's the thing about a new era. It's yours. The all-new Audi Q3. Q, a new era.
we are ready to resume. Please make sure that your devices are quiet. Thank you.
Who's leading in this one?
It's me, Chair.
Good morning, Ms. Sigels Nube. Good morning, Colonel Rulofsen.
Good morning, Commissioner.
Thank you.
Good morning, Chair. Good morning, Commissioners. Chair, the first witness is retired Colonel Kobus de Meyer Rulofs, and he will take the oath.
Colonel, do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you, Colonel.
Thank you, Chair. Colonel, there should be in front of you two files. One is a small file with your witness statement, and then there's a second file that we will be using which says IDAC Exhibit Bundle, Witness Bundle. You should say Witness Bundle. Do you have it?
Yes, I do have it.
And then if I could ask you to go to the file with your statement, and if you can confirm that page 12 of that statement, the signature on page 12 of that statement is your signature.
Yes, it's correct. It's my signature.
And do you confirm that from page 1 to 12 is the statement prepared for purposes of your evidence today?
That is correct, Commissioners.
Do you confirm the correctness of the contents of the statement?
I do.
Okay. Colonel, so if we can start with your evidence, and usually what seems to be assists with flow of the evidence is for you to read your statement into the record. But of course, there will be instances where we will ask questions of you, and where you feel the need to elaborate, or where you've failed to state something and want to now deal with it, you're more than welcome to do so at the appropriate time as you're going through your statement. So don't feel restricted by us saying that you must read your statement. You are welcome to add as we go along.
Yes, thank you,
Okay.
Commissioner.
Shall we start at the introduction, which is paragraph 1?
I was a member of the South African Police Service, SAPS, with the rank of Colonel attached to the Directorate of Priority Crime Investigations, commonly known as the TPCI, and also known as the Hawks. I retired on the 31st of January 2025. In May 2020, I was part of a team. Maybe I must just clarify the team. The team just consisted of me and Captain McLean.
Captain Mark McLean.
Mark McLean, yes. Relating to this matter, there were a team placed at IDEC with more members of the DPCI, but in terms of this matter and CI, crime intelligence investigation, it was just me and Captain McLean and myself. As part of a team placed at the Investigative Directorate of the National Prosecuting Authority, or now known as IDEC, with a special assignment to conduct investigations relating to inter alia state-owned enterprises. Captain McLean and I also investigated matters relating to Crime Intelligence Division, including the Secret Services account that we started in 2011. While conducting investigation into crime intelligence, we became familiar with crime intelligence officials who would provide us with information. At times, these officers would provide information into ongoing investigations or matters that we were not aware of.
Is the voice carrying sufficiently? Colonel, can you please sit centrally in relation to the two microphones? Try to be central to. No, just you, yeah, centrally, yeah. And pull them as close as possible if they do come closer.
Is that close enough, Commissioner? My wife told me to speak up. So,
You better obey then.
yeah.
Yeah, let's continue. Paragraph 3, I think.
Paragraph 3 of my statement. The purpose of this statement is to inform the Commission of a matter regarding events in 2018 reported to Captain McLean and me in 2022 involving Advocate Andrea Johnson and Major General Khan, Feroz Khan. Commissioners, for context, maybe I should just refer to our investigation in 2020 against, in terms of crime intelligence, and the conduct that was that we experienced at the time, which included the using of the media to put pressure on us when we investigated this matter from crime intelligence. Major General Khan has played a huge role in that. In fact, I have a witness that's still in the program who testified or who has provided me with an affidavit regarding General Dramat at the time, where he was a witness to a conversation where General Khan was also, to place a media report regarding the rendition to get rid of General Dramat, so that, because we were reporting to him directly at the time. So that media report was then placed, and there was a lot of fallout in respect of that. But that is what they are capable of, and that is what they are doing. So I expect no less now than what we went through. That's only one incident that I'm now informing this commission of. There were various other incidents of the same thing in 2011. We have informed the police management at the time of this. I've given so many briefings to police management regarding crime intelligence and the things that they were getting up to. But nothing was done. In fact, we were just, firstly it was covertly. They tried to stop us covertly, but it later on just became overtly. So between the police and the NPA, we struggled about 15 years, 12 years to get a crime intelligence matter on a roll because of all the interference that we experienced. And I testified to this in the Magoro Commission as well as the Zondo Commission relating to these incidents. We could have stopped this in 2012 or 2011 if the police had listened to what we were saying to them. Sorry, Commissioner, there was just a little bit context in terms of what we have been experiencing.
Sorry, Colonel, as I understand it, what you really wanted to mention this as to give context regarding this specific incident, that it's not an isolated incident, and the significance of this incident, although it relates to a smaller matter, there were bigger matters that were being investigated.
That is correct, Commissioners. This is a pattern of behavior that I've experienced, and this specific incident just forms part of that pattern of behavior. The impunity, the fact that they think they can get away with it, and they did for a long time. So that it is in that context that I am referring to what happened in 2011, because how do they say? I've seen this movie before.
Thank you, Colonel. Then if we can go to the next page.
Paragraph 4. Sorry. Sometime in May 2022, a colonel who was a captain at the time of the incident, and in 2018, and a lieutenant colonel when she approached us in 2022. In crime intelligence, approached Captain Mark McLean and me to make a disclosure which I deemed to be in terms of the Protection Disclosure Act of 26 of 2000. She informed us that in 2018, she shared an office with General Khan, who had been appointed as the head of Operational Intelligence Support in September 2017. General Khan shared an office with the Colonel and another member of Crime Intelligence because at the time he had not yet been assigned to his own office. The Colonel informed us that on 4 July 2018, while she was working in the office, General Khan, who was attending a meeting in the main boardroom, approached her, handed his cell phone to her, and requested her to give her email address to the person on the other end of the phone. General Khan told the Colonel that the person on the other end was Andrea. She did not immediately recognize the voice, but it was a female voice on General Khan's phone. Paragraph 6. According to the Colonel, the female caller requested her personal email address, and she complied. The Colonel told us that the female caller told her that she would send an email, and the contents of the email must be given to General Khan, and thereafter the Colonel must delete the email. Shortly after the call, the Colonel received an email from a Gmail address bearing the name Andrea Johnson at...
Colonel, you don't have to read the Gmail address into the record.
Okay.
So you can just start with the subject header.
The subject header of the email was Petlek complaint. The email had photo attachments and an audio file. The email contained photographs of the A1 statement of Brigadier Petlek, at the time a crime intelligence officer, in a criminal complaint by her against General Khan for assault common and intimidation, as well as a J88 report, medical report, and an audio recording of General Khan taken at the time of the alleged incident. The alleged incident took place on 26 June 2018, and the A1 was commissioned on the same day at Silverton Police Station, and a case opened under Silverton case number 42206/2018. The email from Andrea Johnson Gmail address to the Colonel's private email address was a forwarded email originating from Barry Bateman, who at the time was a senior journalist. Mr. Bateman had sent the Petlek complaint email with the attachment to the Andrea Johnson Gmail address on the 3rd of July 2018.
Rover, here. Come here, boy.
I'll be right back.
Good, Rover. Come on, sit. Okay, let's go home. Rover! Rover, stop! Rover, what are you doing? Rover! Will you stop that, Rover? Oh, you silly dog!
Sorry, where were we?
You crazy dog.
Red Bull gives you wings.
That is correct, Commissioners. That is the email that what was provided to me that she received. And she was able to retrieve the email from her email box.
So on page 5, what we see is that at the top page, the top of the page, it says forward Petlek complaint, and then it has Andrea Johnson and a Gmail email address to the Colonel at her Gmail address, and it is sent from my iPad, meaning that the Andrea Johnson sent the email from her iPad, and the email is dated Wednesday, 4 July 2018 at 12:42 p.m. Correct?
That's correct.
And then just below that, it says begin forwarded message. So she was forwarding a message that she had originally received from Barry Bateman on the 3rd of July 2018 at 18:05:01 to Andrea Johnson, subject same Petle complaint. And then there is a message in his email saying, I've included the recording, signed BB.
That is correct, Commissioner.
Thank you. Commissioners, we're just having an issue with displaying the redacted version. I think they haven't done the connection.
Let's continue.
Yes, thank you,
Yes. At least you've
Okay.
placed the entire content of at least the cover email on record.
Thank you. Then if we go back to your statement. So, Chair, it's being displayed now. And then if we can go back to your statement at paragraph 8.
Yes, Commissioners, the Colonel had essentially disclosed to us that General Khan was giving the contents of the criminal complaint against him when he was not entitled to the contents of the docket. As the suspect, and importantly, before he submitted an warning statement as a suspect. At this stage, General Khan had not been charged and no decision had been made whether or not to prosecute. The Colonel informed us that General Khan's statement in the criminal complaint was typed by another colleague in the office on the same day, and that the email was received and commissioned by her, the Colonel, also on the same day, being the 4th of July 2018. In other words, General Khan prepared his statement with the benefit of the evidence against him. This was particularly concerning in this case because the complainant and the suspect worked at the same place, and the suspect was the complainant's senior and direct superior. Receipt of such sensitive information would enable the suspect to manufacture and tailor his version, but also approach other witnesses to influence their versions before they are approached to submit statements. Paragraph 9, we informed the Colonel that she would have to provide us with an affidavit setting out this incident, and we will investigate the matter further.
Thank you, Colonel. If we can just pause there and go back to the exhibit file and just to identify the attachments to the email that was sent by Andrea Johnson to the Colonel. If you can go to page, you'll see at the foot of page 5, you'll see it says 13 attachments, and then it goes over the following few pages until page 18. You'll see if you go until page 10, these are all the photographs, and can you just identify to us what those photographs were of?
Commissioners, these were photographs of the actual statement of the complainant, Brigadier Petle. I can't read them from this. My eyes are not that good. But they are, presumed they are a full
There are
version.
better copies from page 11. But
So what I know from this, not from reading it, but what I know, I recognize the documents from what she's given to me at the time and on which affidavit was prepared.
And then you also said that it included an audio recording, correct?
That is correct, Commissioners.
And
I
we
think
see
the
that
audio-
on page 10, the last attachment on page 10 says 2018-0703 audio with a number.
787, it's also on page 8, the top of page 8.
Yes.
Yeah, and then
Now-
there's also photos of the J88 that was inside the docket at the time.
Yes, the J88 appears on page 9, the second last photograph on page 9.
That is correct, Commissioners.
Is it correct then that, especially when you make reference to the J88, that these documents would have been the content of a docket?
That is correct.
It's a proper description.
That's correct, Commissioner. It would have been in the docket itself.
Thank you.
And then if I could just ask you, Colonel, why was it so concerning to you that the suspect in this case, General Khan, had been given the contents of the docket? I know you say there's issues about he may influence the investigation, but at which stage, I mean, we do know that if somebody is then charged as an accused person, they are entitled at some point to the docket. Why was it a concern that it was at that stage?
Commissioners, when we got hold of the docket, because we went to the police's archive and we physically fetched the actual docket, it became clear from the docket and the entries in the docket that General Khan would have been interviewed on, and now I have to rely on the date that the interview was held, and I can't remember that specifically on the top of my head. But he was supposed to be interviewed by the investigating officer on that specific day, and he received this document just prior to be interviewed for a warning statement on that specific day. So he would have known the contents of the complainant's statement prior to him submitting his warning statement. And to me, that's a huge red flag and a very huge concern, because you're not entitled to any statements at that point in time. You're entitled to what the charge is. And I think in this case it was assault common. Happened on such and such a date. That is what you're entitled to. And they do give you that information when they take your warning statement. But to come to the investigating officer with a prepared statement, warning statement, seems to me that you had to have prior knowledge of your version of events based on the evidence that was given to you and on which you can base your affidavit. So that was my biggest concern. We can't sit and put our thumb on the scales of justice one way or the other. It has to be done correctly.
In sum, you are saying having the complainant's statement, there was, at the lowest, there was the possibility of him tailoring his version in accordance with the content of the statement.
Yes, Commissioner. In fact, I will go a little bit further than that, because there's no other reason as to why you want the complainant's statement beforehand. You want to see what she's saying or he is saying. Yeah. And you have to then, and you will tailor your version in so that it doves with what the complainant says. So it's difficult for me to understand any other reason for you doing it, because that's the only inference that I take away from this, and that is why it was so concerning. And I mean, this kind of modus operandi is being, I've seen this before, where suspects get access to documents prior to them having warning statements, or prior to them when they are supposed to be, when they're only entitled to have documents. So this does happen, and in this specific case, it did happen.
How does that differ from a situation where before a witness testifies in court, that is a criminal court, they actually do get the statement? So in a sense, one could say or make the point that the situation is similar. So what's the difference?
No, it's not similar, Commissioners. From my point of view, and I mean, as an investigating officer, it is very important to me to, when I do a warning statement, that I inform the suspect of the complaint, not what the witness was saying, because I need the suspect's version of events, if he is going to give it to me or not. That's a different ballgame. If he's not giving it to me, then obviously I can't take it further. But if he is willing to give it to me, I can't tell him beforehand what the suspect said, because it's unethical and it's not allowed. So,
Thank you. Thank you.
Can I just find out, in the normal course of events, when does a suspect become entitled to the contents of the docket? So if things are done procedurally, when does the suspect become entitled?
Procedurally is when he's either represented or not represented, and the court and the case is before court, and there is a disclosure to the defense, either through his lawyer or to himself, the suspect himself. That is when you get entitled to the documents.
So it's after you are charged?
After you charge.
Not during the investigation?
That is correct, Commissioner.
Thank you.
But Colonel, at this point, Ms. Johnson would have been in the NPA at this point.
That is correct, Commissioner.
Is there in terms of process, is there a legitimate basis on which she would have had access to the docket at this point of things?
No, Commissioner, but I just want to make, to clarify, we're talking about 2018 now.
Yes.
Yeah. No, there was no reason for, it was a station matter. In other words, it was confined to that specific police station. And I can't remember which jurisdiction in terms of court they fall under. What did I say? It was the Silverton case.
Silverton, yes.
Sorry? Silverton case, yeah. So they would have fall under that jurisdiction of that court, for that area. So in the normal course of business, she doesn't have any reason as to why she wants to get hold of the docket. And in fact, if she wanted to get hold of the docket, she probably would have been able to. She could have just called for it because of her position within the NPA, and I think she was head of organised crime at the time, if I'm not mistaken. So she would have been able to call for the docket in her capacity as an advocate within the NPA. And whether there was a reason for her to call for it, I don't know, because it would not normally fall within their mandate, what they investigate and what they prosecute. But under normal circumstances, there is no reason for her to request a docket.
Thank you.
And also other situations where there would be early access by prosecutors are those instances where the investigation is prosecution directed. So there are those instances where.
Yes, but
yes. I'm not countering what you said. You are saying, but.
No, what I'm saying is, at the time, you must remember this is at the station level. So you're talking about prosecutorial advice in terms of a docket. What I can't say now is whether the docket went to a prosecutor before the time or not. And if it did, yes, that prosecutor can have access with guidance.
Yeah, I'm just talking generally.
Yeah, no, I understand that. So, but she could have contacted the prosecutor as well.
Yes.
So she didn't have to contact someone else.
Thank you.
Thank you, Colonel. Then if we can go back to your statement, page 4, the investigation. That's the heading.
In June Paragraph 10. In June 2022, after the meeting with the Colonel, I wanted to interview Mr. Bateman regarding the email. He sent on the 3rd of July 2018. I contacted Mr. Andrew Leesk of AfriForum because Mr. Bateman was now employed at AfriForum as a media manager. Captain McLean and I interviewed Mr. Bateman in the presence of Mr. Leesk and Advocate Harry Nell, also of AfriForum. Mr. Bateman informed us that he received the email attachments on the 3rd of July 2018 via WhatsApp from a source that he was not willing to disclose. Mr. Bateman said that Advocate Andrea Johnson, who at the time was a senior public prosecutor in the National Prosecuting Authority, requested the information from him, being the A1 statement J88 and audio file, and he complied with the request on the same day. I could not remember why Advocate Johnson requested the information.
He could not.
Sorry, he could not remember. Paragraph 11. Mr. Bateman also stated that he had a very good relationship with Advocate Johnson going back to 2011.
Colonel, your voice is tapering
Sorry.
again. Just raise it. Please listen to your wife's advice.
Sorry, wife. Mr. Bateman also stated that he had a very good relationship with Advocate Johnson going back to 2011. He saw nothing untoward about Johnson's request. Mr. Bateman was requested to provide a statement regarding the matter. Despite numerous follow-ups prior to my retirement in 2025, January, for the statement I was informed that he only provided the statement to Captain McLean in June 2026, 4 years after we met with him and requested the statement.
Thank you, Colonel. Can we then go to the exhibit bundle and go to page 45? And I just have a few questions for you regarding the interview with Mr. Bateman. 45, it says BB1. It is an attachment to Mr. Bateman's statement that he provided to Captain McLean this year, but I just want to deal with the attachment to that, which is the WhatsApp that he received from his source with the information, correct?
I'm sorry, just repeat, who is it from and to whom?
The BB1 is what Mr. Bateman indicated is the WhatsApp conversation where he received the information from the source that he eventually sent to Advocate Andrea Johnson.
That's correct, Commissioners.
And the first, you see it's on the 3rd of July 2018 at 11:08, the source sends the audio clip, and his message, Mr. Bateman's message is, "What's this about? I make out a General Khan and Brig Pekle." And then the next message is from the source, an incident between them. He allegedly also assaulted her with a pen. Case was opened, assault and intimidation. And Mr. Bateman then asks, when did this take place? The source says a week ago. And then Mr. Bateman says, how assault with a pen? And then you can see that on the left, the attachments are being sent, the same attachments that we looked at earlier, which is the A1 statement.
That is correct, Commissioners.
Now, can I just understand, so we're now in 2022 when you meet with Mr. Bateman, Mr. Leesk, is it Leesk?
Leesk, yes.
And Advocate Gerry Nel of AfriForum.
That is correct, Commissioners.
And we understand, of course, Mr. Bateman's decision not to reveal his source, but did he explain to you how it came about that Advocate Johnson requested the information? How did he say that, how she knew that he had this information and had received it the very day that she requests it from him?
Commissioners, he maintained from the first time that I saw him, he did not deny that he provided the documentation and the WhatsApps. What he couldn't remember at that time is why it was asked of him. But he confirmed it was asked by Advocate Johnson, but he couldn't remember as to why it was asked from him. He is explaining it in the sense that, you know, we are in communication regularly, so it might be just, he was giving her information, she was giving him information from what I understood. So it might be in that context. He can't specifically remember why she asked him. But she was specific in terms of what she asked him, because otherwise he wouldn't have provided this.
Yes, if you just look at page 46 of the bundle, because then I just want to, if you look at page 46, this is the email that he sends to her later that evening, 3 July 2018, at 8. So he sends it to her, 6 hours? Six, 7 hours later, 6, 7 hours later, he receives it that same day. So when you engage him, did he explain whether he already had the information and she knew he had the information, or whether she asked him to get the information and he then got it? Because it can't be a coincidence that she requests it on the very day that he receives it from a source.
Now, the impression that I had during the whole conversation is that, she specifically requested this docket. He wouldn't have known giving it to her if it wasn't requested.
Yes.
Which is, as far as I'm concerned, a logical answer from his point of view.
Yes, her request, yes, but how would she know that he had it and had received it that same day that she requests it from him?
From what I understood, she requested him to see if he can get it.
Okay.
So he was supposed to source the documents and then provide it to her.
So he initiates her request and asks his source to get it.
That is what I understood. Yes, that is correct, Commissioners.
That would seem to be in line, because any other scenario wouldn't make sense. It would just be a happy coincidence for her to ask it on the same day that he had. has it without even knowing that he had it. She would have to have known that he had it to request it, or, as you say, the impression you had was that she requested him to obtain it for her.
Yeah, I think one should also take into account that between the request on the same day, which was in the morning, it was only sent in the afternoon late, which suggests to me that it took some time for him to source the documents.
Yes, but it would seem that on page 45, by 12 o'clock at least, he already has it, because the attachments start coming in at 11:24.
That is correct.
Yes.
Commissioners.
And he gets the audio recording at 11:08. So if it was an instance where she requested it from him to obtain it, so he didn't have it at the time that she made the request and she wanted him to get it for her, then I suppose he gets it, and we don't know what informs his decision to only send it later that evening, because he only sends it at 6 in the evening to her.
That is my sense when I had an interview with him in terms of what happened.
Okay, but
That
he
is what he
didn't
explained.
specifically give you the information about how the request came about, whether it was her asking him to get it for her, or whether she knew that he already had it and asked just to send it to her.
No, Commissioners, as far as I'm concerned, he was quite clear on that. He was asked to source the documents.
Okay.
Because he wouldn't have otherwise. I do not see a scenario where he would volunteer information like that to her.
Mr. Mube, because we have Mr. Bateman's statement, I think you should put on record what he says about this topic. And I know you've had the discussion with the Colonel and you have an account from his interview of Mr. Bateman, but I think in fairness to Mr. Bateman and for completeness of your discussion, you should put what he says. So it seems he deals with it from paragraph 5, maybe, and then
On page
6 and 7.
Yes. Commissioner Baloy, the reason why I'm asking the Colonel is because that interview happens in 2022 and this statement is in 2026. So I just wanted to know, when he had the conversation in 2022, what was his version as to the request? Because in 2026, Colonel Rulofse wasn't around when the statement was taken. That was Captain McLean.
I understand that, but because we do have the statement on this very topic that you're canvassing, I think it should be put to you.
So if you go to page 40 of the bundle, that's Mr. Bateman's statement, which he deposed to in June 2026. And at paragraph 5, he says, in July 2018, a voice recording and pictures of an affidavit deposed to by Brigadier Petle of the South African Police Services was sent to me. The recording was of a conversation between SAP's Major General Feroz Khan and Petle. 6, I received the information from a source whose identity I cannot reveal. I attach here to a redacted screenshot of the message. 7, I don't have any recollection of the circumstances that led me to send the recording and documents to Johnson. However, I can only infer that it was following a discussion and in response to a request from Johnson. I received the information and sent it to Johnson on the same day, 3 July 2018.
Commissioners, it is more or less in line in terms of what was said to me. I think this is now 4 years later. I think he probably couldn't remember all the detail that he gave to us when we had the conversation with him in 2022. So, but it is in line, and that is how I understood it as to what had happened. There was a request, and based on the request, he would have provided the information.
Thank you. Okay. We can go back to your statement. At paragraph 12, page 5.
In August 2022, I received a statement from the Colonel setting out the events on the 4th of July 2018. At this stage, Advocate Johnson was the head of IDAC, where I was placed even though I was attached to the DPCI. I could not approach Advocate Johnson given the allegations of interference and defeating the ends of justice. At this stage, Captain McLean had also ascertained that the NPA decided on 15 December 2021 already not to prosecute the assault and intimidation docket. And the docket had been withdrawn from the CAS system on the 13th of January 2022.
Colonel, what does it mean the docket had been withdrawn from the CAS system?
It actually should read closed, Commissioner. What we have a CAS administration system, which is an administration system for our dockets. So when the case docket is opened, it would be registered on the CAS system. So at the end of an investigation, whether it is unfounded, whether a warrant of arrest was issued, you will then close the docket and it will be closed on the CAS system. As in, I think in this specific case, it was a nolli prosecute, if I'm not mistaken. So the docket would have been closed on the CAS system as a nolli prosecute. But as I said, I don't have the docket in front of me, so I'm not sure exactly as what it was closed. But then it get archived. So that is in essence what happened. So there won't be any further queries on the administration system, bring forward dates and that kind of thing. But the docket will show that it's been archived, and you can go and find the docket there.
So it doesn't mean, because that's how I had read it, because I don't know your systems. So when you say withdrawn from the CAS system, I had read it to mean it had been deleted from the systems. You wouldn't find it.
It cannot be deleted.
Okay.
There will always be an audit trail,
Okay.
so you can't delete that.
Thank you.
Okay, page 5, paragraph 13 of your statement, Advocate Johnson's knowledge of the allegations against her.
I decided to approach the national head of the DPCI, Lieutenant General Labia, for assistance because of the circumstances that I found myself in. I met General Labia in the last week of August 2022, but I do not recall the exact date. I informed him of the allegations contained in the Colonel's statement and furnished him with a copy of the Colonel's statement. I told General Labia that we needed the NPA to assign a senior prosecutor to the matter. I expected General Labia to request the NPA head, at the time Advocate Shamila Batoy, for a senior prosecutor to be assigned to the case. I could not take the matter to a lower court due to Advocate Johnson's position as head of IDAC. Advocate Johnson's position also placed me in a precarious position because I had been placed at IDAC in Advocate Johnson's office as part of a duty arrangements between the DPCI and IDAC. Paragraph 14. On 7 September 2022, Advocate Johnson approached me at work. I was still at IDAC at the time, and asked me to see her in her office. She told me that she had been called by Advocate Batoy's office, who informed her of the Colonel's affidavit and the allegations against her, Advocate Johnson, contained therein. Advocate Johnson told me the name of the Colonel who deposed to the affidavit. I found it extremely concerning that Advocate Batoy would have told Advocate Johnson about a protected disclosure implicating her, Advocate Johnson, in wrongdoing. I also thought that perhaps Advocate Johnson was able to figure out the identity of the Colonel without Advocate Batoy informing her thereof. But then Advocate Johnson to continue to reveal that she knew the Colonel's affidavit was commissioned by Colonel Wittendahl, and she relayed information contained in the Colonel's affidavit. She then told me that she read the Colonel's affidavit and that she denied any wrongdoing. Paragraph 15. She also informed me that she spoke to Mr. Bateman before meeting with me and told Mr. Bateman not to worry. She also said that she understood the reason I approached General Labia. By this I understood Advocate Johnson to mean that given that the allegations implicate her, she understood why I did not deal with the incident within IDAC, but instead went to the head of the DPSI. Paragraph 16. When Advocate Johnson approached me on the 7th of September 2022, I already knew that she had spoken to Bateman. I can just say here that I didn't tell her that I knew that she'd spoken to Bateman. Because Mr. Leesk told me that Bateman had informed Mr. Gerenel of the conversation between him, Bateman, and Advocate Johnson. Mr. Leesk did not give me the details of what was discussed between Mr. Bateman and Advocate Johnson. I do not recall the exact date when he would have informed me of the call, but from my WhatsApp exchanges with Mr. Leesk on 5 and 6 September, I think it would have been on the 6th of September 2022. Paragraph 17. During our investigation, I was able to confirm that General Labia met with Advocate Betoy on the 2nd of September 2022. That was confirmation for me that General Labia gave the Colonel's affidavit to Advocate Betoy, which I did not take issue with, since my reason for approaching General Labia was for assistance with the appointment of a senior prosecutor. To my knowledge, the only people who had sight of the Colonel's affidavit when I met with General Labia were the Colonel, Captain McLean, General Labia, and me. Advocate Betoy is the only person I can think of who would have shown or given the Colonel's affidavit to Advocate Johnson after General Labia gave it to her at the meeting on September 2022. I do not believe that General Labia shared or showed the Colonel's affidavit to. I do not believe that General Labia showed or shared the Colonel's affidavit with Advocate Johnson. The irony of the situation was not lost on me. Advocate Betoy, by sharing the Colonel's statement with Advocate Johnson, did the same thing Advocate Johnson had done by sharing Brigadier Petley's criminal complaint against General Khan with him. Paragraph 18.
Sorry, before you proceed, Colonel, in this discussion with Advocate Johnson, did you ask and did she say why it was that she forwarded the documents to General Khan? Did she say anything about that?
Commissioner, she said nothing. I would have expected under the circumstances, if she was given access to the affidavit of the complainant, of the Colonel, that I would have expected, that was my expectation. Firstly, I didn't expect it would have been given to her, but now it has been given to her. She had access to it. I would have expected the following reaction. Where can I sign the affidavit? Because this was done, I was duped by providing this information to him. I understand the problem, and I think I need to provide you with an affidavit to further your investigation. That is what I expected, because to me that would have been the right thing to do. But she did not touch on why she asked for it. She did not try to explain the situation. She just said to me, and I think it's quoted here somewhere, I didn't do anything wrong. And that is the extent of what she said. And apart from that, she was telling me about, she spoke to Bateman. She's now speaking to me. We both are witnesses in this matter. after that conversation with Bateman, it took us 4 years to eventually get Bateman's statement. So from where I sat, that call did in fact play a role in him not finalizing his affidavit. And it's a very subtle way to tell someone not to assist in an investigation. I mean, a mere fact, in one of the WhatsApps, she tells him, I'm giving you a heads up, the Hawks will come and talk to you. I mean, you don't do that. That's not your function to do that kind of thing. So I had a huge problem with the situation as it was. I've been fighting with the NPA, as I said, since 2011. So I've been through this process. I know that when the NPA is not going to prosecute or do not want to have a look at the docket or at the situation, they will not. So it took the matter that I was with, the Madlanga matter, it took it about 12 years to get into court. So I knew at that point in time when I had this discussion with her that we are very limited in terms of what we can do from now on, because I'm not going to risk the colonel's career and life by continuing a situation that I now know for sure the NPA is not going to do anything about. So that is the position that I found myself in, and I was very upset by it. So, but it happens within our environment at times, so you have to deal with it.
When she says, I did nothing wrong, when she says that to you, did you understand her to say, by forwarding these documents to General Khan, she did not consider that to be anything wrong about it? Was that your understanding of her?
That was my understanding from the comment she made.
Yes.
So there was no explanation as to why. Because on the face of it, there cannot be, and that's my interpretation, there cannot be a good explanation as to why you did it, except if you didn't know and you were duped. And then I expect the other reaction, which I described earlier. Where can I sign the affidavit? Because I was put in a position where I was not supposed to be put in. And you get that normally with a lot of these cases that you investigate, had I known that scenario. So if she had known, then she would not offer assistance in terms of an affidavit. If she did not know, I would have gotten assistance. So that is how I see the situation.
Thank you, Colonel.
Thank you, Commissioner. Colonel, back to your statement, paragraph 17 on page 7.
I have led many investigations into corruption by police officials within SAPS and with a specific reference to crime intelligence. I'm well aware of how important it is not to prematurely release the name of a witness. It puts the investigation into jeopardy, and more importantly, it has the potential to put the life of the witness in danger. This is amplified in this specific situation because General Khan and the Colonel were both working at crime intelligence in the same office at the time. As stated earlier, before my meeting with Advocate Johnson, I had already been informed that Advocate Johnson had spoken to Mr. Bateman about the Colonel's affidavit. My interaction with Mr. Leeks on 5 and 6 September is set out below, and I have provided the Commission with the screenshots of the exchange as well. Mr. Leeks told me that Mr. Bateman sent a WhatsApp message to Advocate Gerry Nel after his conversation with Advocate Johnson on 5 September. I quote the conversation between Mr. Leeks and me below, as well as the forwarded messages with my translation from Afrikaans to English where necessary.
Thank you, Colonel. If you can just pause here, Commissioners. The conversation appears on page 49, the screenshot. And The Colonel had apologized for the quality thereof. He needed his daughter to assist him with taking the screenshot. So it's on page 49, and you will see the that is between you and Mr. Leesk on
That-
the, yes,
That is correct, Commission. That is between myself and Mr. Leesk.
you may proceed, Colonel. You don't have to read the date and time in. We are looking at the screenshot, so you can just read the translation perhaps from Mr. Leesk.
The translation from the affidavit.
Yes.
It says,
Par-
I Cobus, we need to talk, which is on the 5th. And on the 6th, there's a missed call from Mr. Leesk. And also on,
I think you're now at paragraph 20, so there's the missed call, and then you explain what happened after there, because there's a gap between the missed call and the next message. So you can just go to your statement, paragraph 20.
paragraph 20, although I do not have a clear recollection at this stage, clear recollection, at this stage, Mr. Leesk and I must have had a telephonic conversation about the matter. I recall I was in Cape Town between 2 and 6 September 2022 and flew back to Gauteng on the 6th of September 2022. It would have been in the afternoon. I think it was during this call on either the evening of 5 September or 6 September 2022 that Mr. Leesk informed me of the conversation between Mr. Bateman and Advocate Johnson. I say so because after Mr. Leesk requested us to talk, he missed his missed call. The next message is from me asking which number was used, referring to the number that Advocate Johnson used to contact Mr. Bateman. During this call, Mr. Leesk told me that Advocate Johnson contacted Mr. Bateman to assure him not to worry. I remember asking Mr. Leesk to tell Mr. Bateman to immediately make a note of what he could remember and was discussed with Advocate Johnson. The WhatsApp exchanges continue below. At 14:25, I asked which number was used. Mr. Leesk responded. I'll read the English version. BB says he got a call on WhatsApp, and she said he must go to Signal. I don't know which one she used, but it was to her number. And then it says, it gives a number and it says, I'll find out. Then I send him a thumbs up.
If we can just then go to that message where that references that Mr. Bateman said that he got a call on WhatsApp and she said he must go to Signal on page 58 of the exhibit bundle. If you can just explain to us what we're looking at on page 58.
This is a screenshot or a photo that I took of, I think it's Mr. Bateman's phone, with the request by Advocate Johnson to go to Signal.
The request from Advocate Johnson to Mr. Bateman
To
on
Mr. Bateman.
the 5th of September.
That is correct. That's correct, Commissioners. I can also inform the Commission that on various occasions, Advocate Johnson was not only stating to me but to the office as well, you need to use Signal because WhatsApp is not as secure as you think, and she prefers to use Signal because it's much more secure. So I presume that's the reason why he was asked to go to Signal.
And this was the call on the 5th of September, which you knew about already when Advocate Johnson approached you on the 7th of September.
That is correct, Commissioners.
Okay. So we can go back to your statement at paragraph 21.
Mr. Leesk and I arranged to meet to discuss the matter further. He sent me his location because the location was different to where I had met him and Mr. Bateman, Advocate Nell, the first time. And then it just shows a map that was sent to me.
And then paragraph 22.
If I recall correctly, on 7 September 22, I would have met Mr. Leesk after my meeting with Advocate Johnson. I do recall that Mr. Leesk sent the WhatsApp exchange between Bateman and Advocate Johnson and Advocate Nell before I went to meet him. I know that I did not have the WhatsApp exchange between Mr. Bateman and Advocate Nell when I met Advocate Johnson, which means that Mr. Leesk forwarded the exchange to me after my meeting with Advocate Johnson, but before my meeting with him. Paragraph 23, page 10. Mr. Leesk forwarded the WhatsApp messages from Mr. Bateman to Advocate Gerinel on 5 September 2022 to me. These messages are quoted below.
If we could go to page 51 of the exhibit bundle. So this is what Mr. Leesk forwards to you, which is a conversation, which is messages that Mr. Bateman sends to Advocate Nell after he gets the call from Advocate Johnson on the 5th of September.
That is correct, Commissioners, after his discussion with her.
Okay, if you can then just read from the forwarded, sorry, 51.
Must I read from the actual
Yes, I think
document?
It's easier, yeah.
Okay.
I'll just remind you that there is redaction, so I'll tell you when to stop.
Okay, it starts as follows. Sorry to hassle you, Mr. Nell. Andrea just called me. Called to say she was called into a meeting with the NDPP. Libya had approached the NDPP last week with information.
Then you don't have to read the next part. You can start again by, she has provided statement.
She has provided statement about an email that I apparently sent in 2018, something about requesting information. Unclear. Andrea not worried. She says there's nothing that she said to me or communicated that she could not repeat.
Elsewhere on the next page, 53.
In the middle of the page, it continues that she could not repeat elsewhere. Referred to issues between Khan and Petle, said I often approach her about media issues and questions. Told the NDPP she is not interested in seeing the statement. Next page. Saying that if there is to be an investigation, they must investigate. Just wanted to give me the heads up in case the Hawks came asking. Next page. Came asking questions. She says Kobus was approached with the statement, and he works for her, so he had no choice to approach Libya.
By Kobus, that is you.
That is me, yes, Commissioners. Reiterated that as he is not concerned, reiterated, I presume she is not concerned. She has work to do and will get on with what she has to do. Says,
next page.
Says there is something, if there is something to explain, she will. Told me not to be worried. And then there's another photo of the phone itself.
With the message to go to where the request is, are you on signal?
That's correct, Commissioners.
And this, Mr. Leask forwards to you before you met with him.
That is correct.
Okay.
Yes, Commissioners.
Then if we go back to your statement at paragraph 24 on page 11.
While I was in the meeting with Mr. Lees, I took a screenshot of his phone containing the messages from Advocate Johnson to Mr. Bateman on 5 September 2022, where she asked him if he was on signal. Paragraph 25.
Conclusion.
I do not know as a fact that General Labia gave the Colonel's affidavit to Advocate Bateman. However, Advocate Johnson...
Batoy.
Advocate Batoy. However, Advocate Johnson told me that Advocate Batoy showed her the Colonel's affidavit when I met, in brackets, when I met with her on the 7th of September 2022. In Mr. Bateman's WhatsApp messages to Advocate Nell on 5 September 2022, he said that Advocate Johnson told him that Advocate Batoy approached her about the Colonel's affidavit. He says that Advocate Johnson told him she was not interested in seeing the statement. Mr. Bateman also mentioned in his WhatsApp messages to Advocate Nell and Advocate Johnson that's
Told
me,
him that I have no choice.
No choice but to approach. General Labia, this confirms to me that General Labia met Advocate Batoy and gave her the Colonel's affidavit. And thereafter, Advocate Batoy either showed or gave the Colonel's statement to Advocate Johnson. There is a part in one of the messages, and I don't recall reading it, in which Bateman, as part of his WhatsApp messages, says there's an issue between Khan and Petley. Now, that information could have only come from the affidavit itself. From
Yes, it is there. You did read it.
Oh, I did, sorry. So if I did read it, I'm sorry. But that information was in the affidavit.
Yes, it's on page 53 of the screenshots.
If you have access to the affidavit, you would have known that kind of detail.
You may continue. Paragraph 26.
On 31 January 2025, I retired from the South African Police Service. At that stage, we were unable to secure the appointment of a prosecutor to consider both Brigadier Petley's criminal complaint against General Khan and the allegations against Advocate Johnson of what I considered to be defeating the ends of justice. When I retired, the docket was assigned to Captain McLean, who had worked with me on the case from the start and to whom I report regularly on my interactions with role players where he had not accompanied me. I think it's important for the Commission to hear from Captain McLean and the Colonel as well, because they will corroborate my version, especially regarding what I reported to Captain McLean contemporaneously. It may be important corroboration if those implicated them to rewrite history. And then paragraph 28, I hope that my testimony will assist the Commission in its important work.
Thank you, Commissioners. That's the evidence of the Colonel.
Colonel, when you met with Advocate Johnson on the 7th of September, did you mention to her, or did you get the impression, if you did, that she knew that this was a protected disclosure?
Commissioner, I can't answer the question because she did not allude to anything like that. But what I do know, if she had access to the affidavit, which I believe she did, she would have seen it. It would have been in. It was a protected disclosure based on the facts in the affidavit itself.
Based on the facts, you mean the nature of the allegation?
The nature of the allegation, where she worked, the fact that she could be intimidated, the fact that the guy was a superior officer. So those are the things, if you look at the act itself, those are the kind of things that you look out for when it is a protected disclosure.
Thank you.
Colonel, I prefer the Afrikaans because I'm a Rauki.
And I do not prefer the rank because, quite frankly, I'm not a huge fan of the ranks within the police.
The English and the Australians prefer colonel.
Yes.
In paragraph 12 of your statement, you seem to be suggesting that what Advocate Johnson did amounts to interference with investigation and defeating the ends of justice. What is it about her conduct constitutes, according to you, interference with investigation and defeating the ends of justice?
Well, there's Commissioners, there's more than two issues, but the ones that comes to mind is the fact that she would warn a suspect before the time of, and provide the statement before that person is entitled to the statement, the suspect is entitled. And as a prosecutor, she must know that. The second thing is calling the witnesses and calling me in and calling Bateman. That to me is another huge red flag because she is, as far as I'm concerned, an implicated person. She did not deny that she was duped by Khan. She did not say that had I known this was the issue. So that never happened. So as far as I'm concerned, when I was in there and that happened, that is why I'm saying this, that it was done deliberately. There's more than two things. It's also the effect of a call from someone of her stature to a witness saying to him, I'm giving you a heads up, the Hawks is going to come and talk to you. That to me is also not on. And then the second thing is to imply you don't have anything to worry about, sort of trying to comfort the guy. But why make the call in the first place? Because you're telling him actually, you've got something to worry about. So make sure that you say the right thing. That is my inference from the situation itself. Because we don't do things like this when we investigate matters. As an investigating officer, I don't do things like this. So I expect more from a prosecutor when it comes to this kind of action.
And then the documents that she would have obtained from Mr. Bateman, I understand that Mr. Bateman at the time was a journalist?
That is correct.
So is it not fair then to say the documents or the docket or its contents were already in the public domain because the journalist already was in possession of them? Even the journalist himself could have given them to General Khan.
I understand the question, but But the docket or the information in the docket is not supposed to be in the public domain. It got there in an unsanctioned format. Because if you look at it, Mr. Bateman was not entitled to that documents. So it is not part of the public domain. The public domain comes when you go to court and the documents are handed up. Then it is public domain. But at that point in time, it's not in the public domain. The fact that you have a source who gave you the documents does not make it in the public domain, not as far as I'm concerned when it comes to a reporter. You can't circumvent the process just because the source gave you the information.
So in short, you say even Mr. Bateman was not properly in possession of the docket, and Ms. Johnson should have known that when she received it from him, and she should not have shared it with the with the suspect in the assault complaint.
That is correct, Commissioners. And I think what takes it further for me is the fact that she requested that private emails being used, because it was done on her Gmail account. She asked the Colonel to go to her Gmail account, and she also asked the Colonel to delete the emails when it was done. So those things, if it was an above board conversation, you would use your NPA email account. You would request the documents, because you are actually entitled to request documents in her position. But if you want to put a layer between yourself and the request, that is when you go off the grid and you do it that way. She had access to her official email. She did not have to use her Gmail address and did not have to ask the witness to destroy or to delete the emails. So those are the things that is what made it to, that is what informed me of what she did, and in terms of this specific issue.
Thank you.
On the face of it, subject to an explanation by Advocate Johnson, there appears to be impropriety. Just making a comment.
That is correct, Commissioner. There appears to be, and I think to me, and once again, it is it's my opinion. Once again, if there wasn't any impropriety, she would have told me on the 7th. She would have volunteered information. Saying that I was duped. It might not look good, but it is an explanation, and we could have actually gone after General Khan because what he is what she is allegedly guilty of, he is also allegedly guilty of, because he sourced the documents from her.
Thank you, thank you. Ms. Sigels-Ncube, is there a reason why we did not listen to the audio that came with the email?
Chair, we thought that we would play it when
witness N, is it?
Witness O.
Oh.
Yes, it's in the incorrect order, yes, Chair.
Oh, all right.
Or even Captain McLean comes, because he was the investigator.
But are there issues of confidentiality with regard to it? Why should it not? Why should the public not?
No, there isn't, Chair. We will play it. The
in that case, should we not play it here, or will it be played when?
Chair, where Captain McLean comes, because he's the current investigating officer.
All right. No, that's fine. That's fine. was just concerned if we played outside of this
No, we won't.
this
No.
forum.
In this forum, Chair.
All right, all right.
Colonel, at the end of paragraph 17, you read what you describe as the irony in the conduct of Advocate Batoyi vis-a-vis Advocate Johnson, that very last part of paragraph 17. Do you, in so many words, consider the conduct of Advocate Batoyi to have been inappropriate in the same way as well? I just want to be clear what it is you're saying about it.
I do not know. I wasn't privy to the conversation between her and Advocate Johnson or between her and General Labia. But if she's read the affidavit that was given to her, and I'm talking about Advocate Batoyi, she would have realized that what she is doing then by showing that affidavit to Advocate Johnson, that is exactly the same that Johnson did with Khan. So I would have expected her to understand the situation, because what I would have expected from her is to appoint a prosecutor and, if she wanted to, institute disciplinary proceedings. That is what I would expect in the circumstances like this. But that didn't happen. So I was never contacted by a prosecutor. So as far as I'm concerned, there was never a prosecutor appointed. And there was no disciplinary proceedings after that as well. I was not contacted by the NPA for disciplinary proceedings. I mean, if you have an affidavit like that in front of you, you have to take some action. So, and the same applies to an explanation. If an explanation was given to her, I was duped. I didn't know what this guy was going to do with this. Then it is the same explanation that I expected her to give me, but it wasn't given to me. So I'm not sure what took place between the two of them, but I am sure that she should have seen the circumstances in respect of the affidavit of the colonel vis-a-vis the circumstances of the affidavit given to General Khan.
I guess what I'm trying to get in very clear words so that there is no confusion about this is, in respect of Advocate Johnson's conduct to General Khan, as it relates to General Khan, you unequivocally say there was interference with an active investigation. And what I'm seeking to clarify with you is, do you similarly express the same view about Advocate Batoyi speaking to Advocate Johnson about this investigation that you are now conducting into her behavior? Do you consider that to have been an interference in an investigation or not?
Commissioner, it's a difficult question to answer, because as I was not there, so I do not know her intent. So I only can deduce from the actions what the intent was, and I'm not sure that the intent was to derail the investigation. But if you look at what happened afterwards, the fact that no one was appointed, no disciplinary action was taken, and sharing this document, because she must have realized this is exactly the same situation that Advocate Johnson is finding herself in. So under those circumstances, I have no doubt that, let me classify it, she made exactly the same mistake, if you want to call it a mistake, because it's not a mistake, as Advocate Johnson did by her actions.
Thank you.
The
We're done
witness
with the
may be
witness.
excused.
Yes, Chair.
Yes. Thank you very much, Colonel.
Thank you, Commissioners.
Let's adjourn and resume at 11:45.
All right, we are ready to resume the session. Please make sure that your devices are off, that they are quiet. Thank you.
Is it still you?
Yes,
Ms.
yes,
Sigurd
Chair.
Nobe?
Yes.
Good morning, Captain McLean.
Good morning, Commissioners.
Do you pronounce it McLean?
McLean, not toothpaste, McLean, but the A in out.
I'm asking because when I was a student, we had a dean who was Dean McLean, but written exactly the same way.
Same way.
Yes. Yes.
Thank you, Chair. Chair, the Captain will take the oath.
Do you swear that? Oh, please place your full names on record, Captain.
Mark McLean.
Thank you. Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you, Captain.
Thank you, Chair. Captain, in front of you are two files. The first one has a small file with your statement in it, and then the second file is an exhibit bundle. I just want you to confirm in the small file, page 8, that the signature that appears on there is your signature.
That's correct.
Do you confirm that the statement was prepared for purposes of your evidence today?
Correct.
Do you confirm the correctness of the contents of the statement?
It's correct, Commissioner.
Thank you. Chair, given that Captain McLean is corroborating to a large extent Colonel Roelofse's evidence, we have agreed that certain parts of his statement, he won't read it, but he will basically summarize based on what Colonel Roelofse has done, has already testified to, and then he will continue at a certain point with aspects that only relate to him. And when we deal with what it is that the Colonel had given, the information the Colonel had given to him, we will then play the recording as well. Thank you. Captain, if we can then start with your statement on page 1, and you can read this part into the record, and then if there's any portions that you want to elaborate on or clarify, you can do so. You don't have to feel restricted. Thanks.
Thank you, Commissioners. I am a member of the South African Police Services with the rank of a captain attached to the Directorate of Priority Crimes Investigation, also known as the Hawks. In May of 2020, I was part of a team placed at the Investigating Directorate, the ID, of the National Prosecuting Authority, also commonly known as IDAC, as part of a duty arrangement between IDAC and the DPCI, where we were assigned to conduct investigations relating to inter alia, state-owned enterprises, or state-owned entities. We investigated matters relating to the Crime Intelligence Division, including the Secret Service Account, SSA. While conducting these investigations into crime intelligence, the team became familiar with crime intelligence officials who would provide the team with information. At times, these officers would provide information on ongoing investigations or matters that we were not aware of as a team.
Now, Captain, when Colonel Roelofse gave evidence, he mentioned that investigations had started as early as 2011. Were you involved in those investigations?
That's correct, Commissioners. In 2011, I think it was March, it was a public holiday. We were informed to form part of a team coming up to Gauteng to investigate a murder of Opera Mogibi in Vosloorus against General Mgluli at the time.
Okay, and at that stage, was it just you and Colonel Roelofse?
It was myself, Colonel Roelofse, Colonel Viljoen, Piet Viljoen, and Cathy Williams, Sergeant Cathy Williams.
And just insofar as you mentioned the issue about the Secret Services account, was that also part of the 2011 investigation?
Not right in the beginning, Commissioners. Like I said, as things progressed, because you are dealing with a murder of the then Divisional Commission of Crime Intelligence, the officials in crime intelligence will then, you get to know them, and then they will approach you with information. And that's exactly what transpired here.
When you say information unrelated to...
Unrelated to the murder, Commissioner.
And then Colonel Roelofse mentioned something about, he said we could have stopped this in 2011 and didn't really elaborate. I think it was actually my fault that I didn't ask him to elaborate on. Do you have a view on that? Because I had engaged you on that issue as well, about 2011.
Yes, Commissioners. Most of these issues that is arising now, that is coming out in at the Commission, not all, we already knew about some of these things in 2011, and it was brought to the attention of a lot of generals that something must be done. Can
you just please explain these things?
These things was the abuse of the Secret Service account. We opened, at that time, we opened 2 other separate cases that was running. One was against General Lazarus and Colonel Barnard. And then the other matter was General Barnard, General Lazarus, General Mgluli, and Colonel Barnard. The first one was on a Littleton matter against General Lazarus and Barnard for abusing the Secret Service account. What they did was they created within a service provider.
I just wanted to get the nature, not necessarily details around.
Thank you.
Yes.
Thank you, Commissioner.
I think the Chair's question was more about what are these things that you say could have been stopped in 2011?